92.3 Nigeria Info.
Our freedom depends on our proactive responsibilities.
Let's talk, act, and be about development.
With one voice, our potential is realized. This is your number one news, talk, and sports radio station. 92.3 Nigeria Info. I am listening.
We connect you to the world. We connect you to the vicinity. We are Nigeria Info.
Listen to me. I said this is a real situation and the government has to do something about it. What are you trying to insinuate? All these people looting Nigeria's money?
This is Nigeria Info, in the heart of Nigeria. 90.3. We are Nigeria Info.
Our freedom depends on our proactive responsibilities.
Let's talk, act, and be about development.
With one voice, our potential is realized. This is your number one news, talk, and sports radio station. 92.3 Nigeria Info. I am listening.
The rains are here. You know what? The rains have been here. Matter of fact, the rains are still gonna be here. But how about our shelter? How about our roads? Will they survive flooding if we continue dumping refuse in our drainages? Don't wait for the government to stop your neighbors from destroying our environment. Don't pour refuse into the gutters. Floods kill and render our neighbors homeless. Let's be our brother's keeper. Report offenders to the appropriate authorities. This message is from 92.3 Nigeria Info.
And now, Hard Facts.
Hard Facts
With Dio.
Welcome back to the Hard Facts at 90.3 Nigeria Info here in Port Harcourt. I'm Dio. We've got 24 minutes to go before 6 p.m. Discussions continue. Thanks for staying tuned, and the matter we discussed at the moment I mentioned a while ago. There are several maybe seemingly naughty legal matters which will be attempting to disentangle or entangle, if you will. Three matters precisely. We're going to rush through them as soon as we can. And joining me via phone for this conversation, Associate Professor of Public Law at Rivers State University, former Chairman Nigeria Bar Association, Branch. Barrister Ritchard, Wokocha. Barrister Wokocha, welcome. Apologies, I need to reconnect with my guest to stay with us. I think I have my guest back on the line. Barrister Wokocha, you're welcome once again.
Thank you, Dario.
All right, without further ado, let's delve right into them. We've got limited time. Now, here's the first of these three stories. 18-year-old suspects found in trial for allegedly stealing a 16-month-old baby have been treated by a magistrate court in Port Harcourt. Chief Magistrate Ritchard in her judgment freed the 8 suspects after the plea bargain was entered between the River State government and the family of the complainant. Chief Magistrate Agugo ordered the women to pay 1.7 million naira to the complainant and 200,000 naira fine to the River State government. Our correspondent reports that 2 of the women, Grace Azikwe and Berry Blessing Tagona, have already spent 2 years at the Port Harcourt Correctional Center, while Confident Nacho, Love Dumo, Teresa Gabriel, Kate Odana, Patricia Oluje and Regina Akuru have been on bail, and these women were alleged to have conspired to steal the child in a church on Wokocha Street around Wimpy Junction. Now, there are several questions here. Were these women guilty? Would the court have found them guilty of the alleged crime for them to have entered a plea bargain? In this case, should monetary compensation have been paid? If there was a chance of finding them guilty, as far as the matter is concerned. Barrister, what do you make of this development?
I find that is disturbing. the character of the offense is one in which we shouldn't be talking at all about plea bargaining. Stealing of babies, yes, I agree it's a crime, but this is a kind of crime that the entire society should be extremely worried about, and one about which we should expect to see something serious done to discourage those who want to engage in such disorderly act. So here of plea bargaining and setting the person free is, to say the least, very disturbing.
Now, for a plea bargain to have been entered in this matter, does this suggest strongly that either the defendant could it turn down the volume of a radio set, please? Does this suggest that Barrister, please could it turn down the volume of a radio set? Now, does this imply that the women, the accused, are either guilty or would have been found guilty if the matter had gone to trial fully?
Definitely. Plea bargaining does not take place except where there has been an offense. Except where there has been an offense, plea bargaining does not take place. So you can't be talking of the woman paying some fine and paying some money to the victims and paying some fine to government, except that she is guilty. Of course, the idea of plea bargaining too is that the person who is guilty offers to make things easy for the state by admitting the guilt and meeting whatever conditions that the bargain arrives at. As a compensation for that, she gets lesser sentence or punishment than she should have gotten prior to that time. So the idea of setting her free because she has made payment is completely one that is unacceptable and out of the question.
Now, how might this precedent affect these matters of this nature going forward? And here's what I mean. Many times you hear organizations such as FIDA complain that those who have been wronged in matters of this nature do not come forward, but sometimes they settle. Barrister Wokocha, are you with me?
Yes, okay, I'm with you now, yes.
Okay, that sometimes you have organizations such as FIDA having a difficult time investigating and prosecuting these matters, or even the government for that matter, claiming, alleging that those who have been, those on the receiving end, the victims in this case, do not come forward, either because they reach some kind of agreement with those who may have defaulted. For example, in cases of rape and similar cases, you hear that monies may have exchanged hands. And this does not help the legal process or help in deterring future offenders from committing such crimes. So how do you think a judgment of this nature might affect, future incidents of this nature?
It is an improvement. It's better than the state trying to prosecute and not succeeding. And I think in this case, there must have been sufficient evidence which warranted the person pleading guilty. Now, my concern is that the wrong message is sent to society is that you can do this business, and if you are caught, say something, and you will be all right. That's an extremely dangerous message, because when these children are stolen, what they can do with them are things that can generate much bigger amounts than the 1 million naira she was asked to give to the parents. So they can go ahead, and if they are caught, they settle the thing, and it sends the message that you can settle this kind of offense. And then this offense is not stealing by somebody who is not hungry. It's not a traffic offense. It's stealing of baby. It's like saying you are granting plea again and releasing somebody who has been guilty of kidnapping. The character of the offense makes it one which raises terribly strong questions that the state should not, by the state I mean the prosecuting authority, should not at all have the public hear that there was settlement over this kind of thing. Yeah, you can settle living, but the person should be seen to have been punished. Send the person to jail. If he was going to do 5 years, let him do 1 year. And that message is sent to society that we frown at this kind of conduct. But to say that somebody kidnapped somebody or stole a baby and was caught and they paid some money and we are released, that's a terribly wrong message to society.
Is there a possibility of this case being reviewed?
when a plea bargain takes place and the court does what it has done now, the case has been resolved. If you take on the person again, they can plead atrocious can plead that they have been tried before but punished for the same offense, so you cannot punish them again. It will be unconstitutional.
What if the state perceives that the matter was not properly handled? Because I've heard and I've read in the past that even when, especially in other countries of the world, even when a matter has been dispensed to it by the courts, if the state is not pleased with how the matter has been handled, the same matter can be reinstituted. Examples abound. For example, the Blade Runner was Pistorius in South Africa. The case of the homicide case. Even after the trial was ended, there was a retrial because stakeholders were displeased with how the matter was handled in the first instance.
Well, sometimes matters carry civil and criminal characters. And when one says you can try the other and all that, you can establish links between what was suffered and the action of the person, even though he wasn't convicted for the offense. But again, our laws may not be on all fours the same. Once the matter has gone to court and concluded in the court with plea bargaining and the person being discharged, what it means is that under our constitution, that person has been tried and found guilty and punished under our law. So you cannot take on that person in a prosecution for the same set of facts. You can't prosecute him for an offense arising from the same facts over which this has happened. And what stops you from doing that is the fact that he has already gone through it and been punished for it with that fine of 1 million naira to the parents of the child.
1.7 million actually.
1.7 million to the parents of the child and the fine paid to the state. So the person has been punished. And having been punished for that offense, that cannot be tried again for that same fact. So any crime, whatever you call the crime, so long as it relates to the same set of facts, that particular incident, the person cannot be punished again under our constitution.
All right, let's go to the second matter right now. And the EFCC has placed the incumbent governor of Anambra State, Willie Obiano, on a watch list ahead of the handover of government in the state. This was contained in a letter to the Comptroller General of the Nigeria Immigration Service dated November 15, 2021. It's, however, not clear why the anti-graft agency placed the governor on a watch list. Governor Obiano will hand over to Professor Charles Soludo in March 2022 when he completes his 2 terms as governor of the state. Now, what is very clear in this matter for me is a sitting governor, even the president for that matter, as much as they do enjoy immunity, can be investigated by security agencies or financial crimes agencies. However, the EFCC, I believe in this case, has gone beyond that to declare publicly that the governor is on a watch list, and he's still governor, by the way. Is that appropriate behavior or appropriate procedure conducted by the EFCC?
It's a Nigerian procedure. Ordinarily, somebody is on a watch list. The least you expect is that there will be a public statement to that effect. Because the public statement is telling him to tidy up things that they are coming after him. So if you were investigating him, expectation is that you would have been quiet and you would have conducted the investigation quietly without alerting him. That's the essence of such watch list, placing somebody on surveillance and all that. That is the essence. So when you make an announcement, it's on our watch list, you are engaging in the usual media gymnastics that we have always talked about in this country, public parade of suspects and all that. That's exactly what you are doing. You do not need to announce the way they have done. I agree. They have not broken any law by announcing that. They have probably just embarrassed him. That's okay, that they embarrassed him, but it's not an offense. But again, it means they are not serious about what they want to do. It means they are telling him, it's like armed robbers are on the way and police arrive and shoot before getting to that point to scare them off, let them run away. So what you're telling him is to tidy up things that there are eyes that are looking at him. It doesn't look like a serious procedure for investigating a public officer who is being investigated.
All right. Now, responding to this development on behalf of the governor, Anambra State Commissioner for Information and Public Enlightenment, Don Adiniba, has accused the EFCC of acting in script. He said Obiano has 4 months left to remain in office, and the commission went too far by publicly announcing that it is investigating him. Yes, and Adiniba said the governor has made it public that he would relocate to his U.S. base at the end of his tenure. What do you make of this response by the governor's commissioner?
Well, that's okay. Just as I said.
By the way, might I add to that? He also said, quote, Governor Obiano is out of the country and he traveled through one of the country's international airports. He did not disguise himself, but rather left the country with his identity fully disclosed at the necessary immigration point. Please go ahead.
So it means they are aware he is not around. They just want to embarrass him. I'm not surprised by the reaction from the commissioner. I think it's appropriate because you do not need to make such announcements. You do not need to, he's not on the run. You saw him, you were watching him and you saw him travel. Is this an attempt to see if he could be muzzled into not coming back, if he has things to hide in order not to come back? Are they trying to scare him off and all that? That's the point the commissioner was making in saying that it doesn't make any sense. The announcement is unnecessary, as I say, from the point of view of criminal investigation. It's absolutely unnecessary and counterproductive. And then when he said that you're trying to embarrass him where he is, carrying the media that he's a wanted person or something. Of course, the governor cannot be a wanted man until he has left office. So the whole thing does not make sense. And I think the position of the government expressed by the Commissioner of Information in Anambra is in order for me.
Finally, Federal High Court sitting in Yenagoa by Bayelsa State has restrained the EFCC from further investigating a former governor of the state, Tirake Dixon, on the issue of assets declared with the Code of Conduct Bureau between 2007 and 2020. Presiding Justice Issa Dashian in the judgment held that the assets acquired was learned when Dixon was a member of the House of Reps should not be probed any further, having been declared before the CCB, which issued a certificate of verification for them. Your thoughts on this, Barrister?
That's unconstitutional. The power of the CCB is not a power to investigate and verify the authenticity or cleanliness of the funds that are used in acquiring a property. What Schedule 3 to the third schedule to the Constitution provides in Part A of it, which provides for the CCB, is that they should confirm submissions that are made, confirming that the property belongs to the man. The property he claims he has in his declaration belongs to him. That's different from criminal investigation. Criminal investigation may have tracked money to the purchase of that property, stop the list from being able to proceed with that. So the court was wrong. The CCB did not conduct investigation to verify that the money used in acquiring the property was not dirty money. And you cannot, on the basis of the fact that CCB confirmed that he owns such property, declare that investigation should not be done if there is suspicion that there is some crime committed in relation to the purchase of that property. So the court was wrong. That is unconstitutional.
Well, does this raise question marks as regards the role of the judiciary in matters of high-profile corruption cases in the country?
Well, some might to say that, but I take this as a misunderstanding of the judicial officer himself. The questions are completely different. Confirming that a man owns a property is not the same thing as confirming that there was no illegality involved in the purchase of that property. So I think the judicial officer just did not get it right, or was strongly persuaded to rule without.
But might your response not be an attempt at rationalizing this as well? Because it seems quite obvious here. You can't say that a person should not be investigated. This is almost reminiscent of the situation here in Rivers State, where someone got a perpetual injunction asking that or ordering that they can't be investigated or they can't be asked questions as to how state funds were administered.
What I may attempt to be rationalizing is the presumption that it's a reflection of the generality, the general character of the judges of the judiciary in the country. I will stop short of saying that That's why I would presume that this is a function of being unable to look at the matters closely and see the difference between the two things. And he may have been persuaded or allowed himself to be persuaded into that position. But I think the law is pretty clear. You can't stop criminal investigation, especially on the grounds that the person attended, he was the owner, and it was shown that he was the owner. That doesn't answer the question, how did he acquire it? CCTV did not handle that. So the court ought not to have used CCTV clearance as basis for ordering the EFCC not to go on with this work.
Well, thank you for staying tuned so far, especially my guest, Barrister Wokocha, is an associate professor of public law at the River State University, former chairman of Nigeria Bar Association, Ahmad Branch. Barrister Wokocha, many thanks for your time.
You're welcome, Dario.
Got a commercial break coming up right now. Major news support the hour at 6 p.m. If you've missed out on contributing to any matter on the show today, all topics, matters discussed and mentioned are open for discussion afterward on the open season segment. Please stay tuned.